Good morning, everybody. Thank you for joining us, everyone at NECA and everyone from other parts of the construction industry. I'm Joelle Salerno. I'm the Government Affairs Director for Western PA NECA. We're hosting this webinar as part of our Legislative Lunch webinar series for Western PA NECA members that brings in legislators and legal experts for conversations about policies and laws that affect the construction industry. So this morning we have an excellent panel from Cohen Seglias that will be discussing CASPA, which is Pennsylvania's Contractor and Subcontractor Payment Act, and the recent changes that the General Assembly made to the law in 2018. We at NECA and our members helped give input to shape that legislation to give contractors more tools to make sure they get paid on time in accordance with their contracts. So before we get started, a few logistical items and tips for those of you who aren't familiar with GoToWebinar. All attendees' microphones will be muted for the duration of the webinar today. And we are recording this webinar for distribution after the meeting's over. So if you'll look for the GoToWebinar control panel window on your screen, you'll see a bunch of different options there. You can ask questions during the webinar today in the questions box, and that'll make sure that everyone gets a response either during the meeting or afterwards. And then also in the control panel window under handouts, there'll be a PDF link there. I just double checked, it is there. And if you click on that, it will download a new PDF for you of this PDF that of the presentation that you're seeing today. So you will have that for future reference. So that's all that I had. Thank you again for joining us today. And now I'll turn it over to Matt, Dan, and Lisa to get us started. Thanks, everybody.
Well, thank you for the warm welcome, Joelle, and thank you for having our firm present to this group today. My name's Lisa Wampler, and for those of you who don't know me, I'm the managing partner here in the Pittsburgh office of Cohen Seglias. My colleagues, Matt and Dan, are also on the line. Matt is a partner in our Philadelphia office, and Dan recently is being promoted starting January 1 to partner as well. The three of us have one main thing in common, other than the fact that we all do construction, but we're kind of lifers at Cohen Seglias because all three of us basically started our legal careers here and have continued to advance our careers as the time's gone on. So a little bit about our firm. We have about 70 attorneys across 9 offices that provide a wide range of legal services. The Philadelphia office is our main office, and Pittsburgh was the second office to ever be opened, and that was in 2003. We have nearly 50 full-time construction attorneys, and that makes us one of the largest construction practices on the East Coast. We have we do a number of representations for clients. We have over 1,000 of the clients, and our capabilities are across the board. We're basically a general practice. We do business transactions, the construction work that we do real estate, labor and employment, and the list goes on, as you can see. We are here today to discuss prompt payments and to review with you certain statutes that exist not only in Pennsylvania but in the surrounding jurisdictions that might be pertinent to where the listeners today all do work. Basically, a prompt pay claim is created by a statute that has a number of rules and regulations that, if not followed with respect to timely payment for material and labor, they impose a number of unfavorable consequences. With respect to these statutes for prompt payment in Pennsylvania, we have the Public Prompt Payment Act, as well as the Contractor and Subcontractor Payment Act, which is also known as CASPA. With respect to CASPA, I just wanted to give a little bit of an overview before we jump into the 2018 amendments, which is what the bulk of the presentation will be today. CASPA applies to construction contracts for work performed on property located within Pennsylvania, and CASPA applies strictly to private projects. The CASPA regulations require that a paying party pay the contractor or subcontractor strictly in accordance with terms of the contract, and it also has payment provisions to the extent that the contract is silent with respect to when payment should be made. As I mentioned, that if payment is not made when due, CASPA provides the unpaid party to a number of rights and remedies, including interest at 1% per month, and the possibility of penalties, which are charged at an additional 1% per month, as well as attorney's fees. With respect to the Public Prompt Payment Act, this statute applies to construction contracts that are over $50,000 for public projects in Pennsylvania. It's very similar to CASPA in that, again, it sets forth guidelines for when payments are due and provides those types of penalties that I was talking about, but the specifics do differ. The biggest difference being that in order to get those penalties and attorney's fees, you have to show that there was bad faith in withholding of payment. Like CASPA, it requires payment in strict accordance with the terms of the contract as well. Dan, I'm sorry, you're muted.
You know, you try to be polite and go on mute, and then you forget because you can't walk and chew gum at the same time. So my bad. Again, I'm Dan Fierstein. Going to talk you through some of the basics before we jump into the new stuff on CASPA. So let's dive in. Lisa mentioned CASPA applies to private construction projects, and that's for real property located in Pennsylvania. There are a few minor exceptions, probably don't tend to apply to this group here, but residential projects of 6 or fewer units are not subject to CASPA, but everything else in the private construction realm pretty much is. So who does this apply to? There are contractors and subcontractors. Those are defined terms. That's why you see them in quotes. And that basically takes you from prime contractors all the way down 2 layers beneath the general contractor. So prime contractors, trade contractors, even your design professionals like architects and engineers and surveyors, and again, everybody down to the second tier below the prime contractor is going to be able to make claims under this statute. So it applies to all of the payments that are identified in your construction contract. As Lisa said, this statute, the purpose is to level the playing field for those who are farther away from the source of the funds, and that requires payment in strict accordance with the contract terms. Some of the examples of payments that are protected here are typically the undisputed or lesser disputed types of payments, like progress payments, final payments, approved change orders, and retainage. Conspicuously absent from this list are things like unapproved change orders, disputed change orders, delay claims. Those are not really intended to be captured because they're disputed. They end up getting rolled into lawsuits when there are lawsuits that are about multiple types of payments, because they tend to lump in contract balance but also delay claims. So that all gets kind of resolved through the course of the dispute, but the statute's really intended to capture the lesser disputed items. So what is untimely payment under CASPA? When we're talking about progress invoices, it's all about when the money comes in from the tier above you. And you know what, as I'm glancing over here to my panel, we have a question. Is the $50,000 requirement applicable to the whole contract, that is the GC's contract, or to each subcontract? I assume that question is taking us back to the public statute, which has the $50,000 threshold. at the risk of screwing this up, I'm not going to go back to the slide, but my understanding is that we're talking about the whole project, but I don't know if Matt or Lisa have a comment there.
Yeah, that is correct. It has to do with the value of the project, not the individual contracts of the subs.
Okay, great. All right, thanks. And good question. And again, keep them coming. When you see my eyes glance over here, I'm not checking my emails. I'm actually trying to see if questions are coming through. So definitely keep them coming. We'll make it as interactive as we can. So to come back to untimely payment, as you can see here, contractors must pay the sub within 14 days after receiving each of its progress payments, or 14 days after receipt of the invoice, whichever is later. It's almost always going to be the first one, 14 days from receipt of payment, because that almost always ends up being later. One important thing to note here to contractors and subcontractors, in order to be protected by the 14-day provision, you need to disclose the due date for the receipt of payments from the owner. How do you do that? How do you get that information? Well, it's going to start with the general contractor. They obviously have their prime contract with the owner. It's incumbent upon the general contractor to disclose the pay term. Doesn't necessarily mean you have to turn over your prime contract, but you'll probably have to do that anyway, because chances are your subcontracts with your subcontractors are going to say, hey, subcontractor, my prime contract flows down through to you, and you've had an opportunity to review it. So chances are you're just going to organically provide those provisions, but make sure you do provide that pay provision, because if you don't, there's a consequence. And it's going to be treated as if the owner has made payment to the contractor, either 20 days at the end of a billing cycle or 20 days after the contractor's invoice. So you want to make sure that you communicate that downstream. And the subcontractor, when you get that payment information from the contractor, you're going to need to communicate that information to your own subcontractor, because remember, the statute goes 2 tiers down for subcontractors. So this is the fun stuff. This is where all the teeth in the statute exist. And I have to say, Pennsylvania is really about as strong as a prompt pay statute as you'll find in the country. Interest for late payments is 1% per month. That's 12% for the year. Maybe when the market's going gangbusters, you'll get that in the stock market, but you're certainly not going to get it in the bank. Wrongful withholding, tax on another 1% per month. That's a penalty. So you're going to have to show a little bit more than just your traditional late payment. You're going to have to show that the payer party didn't really have a basis to withhold the money that they said they were going to withhold. And we'll talk about that down the road. So that's another 12% annual that you can throw on top of your claim. You can see the amounts will often ramp up, as Matt will talk about on the next slide, to really substantial amounts. Lastly, if you're forced to file a lawsuit or an arbitration and you are deemed the substantially prevailing party, the court or the arbitrator must award you your reasonable attorney's fees. This cannot be waived by contract. So basically, this is the leveling of the playing field, because if you fail to make timely payment, you could be on the hook for interest, penalty, and counsel fees. Probably not worth it to double or triple the damages that you might have to pay. So as a practical matter, it's very costly to get to this point, to pay a lawyer to take you all the way through a decision, finance litigation. This statute is really very useful on the front end. So if you're trying to close out the project and you have a lot of change orders that you're trying to resolve and contract balance that's unpaid, we may write a demand letter that says, look, we could do this the easy way or the hard way. You can pay the principal amount due now, or you can keep fighting when you know you have no business to fight it, and the claim is just going to grow. So it's very useful to get people's attention before it becomes costly and contentious. Matt?
All right, thanks, Dan. I'm Matt Gioffre. With Lisa and Dan, I've been working with the firm, as Lisa mentioned, for a number of years. And like Lisa and Dan, we deal with all sorts of different kinds of claims, delay claims, change order disputes, claims over whether work is defective or not, things of that nature. But almost all the claims we deal with have a payment component where payment is being withheld, and the claim is from the contractor or subcontractor's point of view that the payment is being withheld wrongfully. And that's where CASPA comes into play. And it comes into pretty much all the disputes. So we've handled this statute over and over again, all three of us, on many different projects. And on the slide there, we're sharing a few of the different matters that we were either involved with or we're aware of, where these CASPA damages were applied by the court and really changed a relatively small dispute in some cases to a rather massive obligation for the owner or the developer. So, I'll run through a couple of these with you. The first one on the list is CZ, and that involved a claim against an owner. And what happened in that project is at the end of the project, all of a sudden, when it was time for final payment, the owner came up with a list of completely bogus deficiencies, went through, got somebody to put their name on it and put dollar values at the end, things that weren't an issue throughout the entire project. But all of a sudden they thought, here's a way that I can avoid making payment. I'm going to throw up all of these issues against the wall and just say, we're not paying you anything because of all these problems that weren't real, weren't part of the contract, were a design issue, or something of that nature. So at the end of the day, this is a jury trial I was involved with in Montgomery County, Pennsylvania. The jury awarded $123,000, which was the contract balance, but with the application of CASPA, interest, penalties, and attorney's fees, the owner ended up having to pay over $400,000. So it took a relatively small amount owed and over tripled it, so that the owner had to pay $400,000. Powell Steel, this was a little bit further back in Philadelphia. It involved a project for SEPTA, where the general contractor ended up resolving its dispute with SEPTA, but in the process of resolving that dispute, decided that it didn't have money to pay its subcontractor, Powell Steel, on this project. So Powell Steel was the sub. And there was no basis for the non-payment, just that, well, we made a deal with SEPTA and we cut you out of the deal. Since there was no reason for, no deficiencies in Powell Steel's work and no reason for the non-payment, the court found that the general contractor had violated CASPA in that situation. So with $935,000 as the contract balance, which we were awarded by the jury, after the application of interest, penalties, and fees, that jumped up to almost $3 million that the general contractor was on the hook for. And perhaps the most striking example is the bottom one, which involved the developer, small balance owed $30,000. But that was over the course of 20 plus years. Once that $30,000 was not paid, the interest and penalties continue to accrue, and attorney's fees, as they chase down that balance. That's the thing. Interest and penalties don't stop when the jury makes a decision or the award's given. It continues to accrue until payment is finally made. Payment wasn't made, punitive damages were added on, tons of attorney's fees, interest and penalties, to the point where a $30,000 balance went over $1 million in liability for this particular developer. So the reason why we're sharing this with you is that we want to impress upon you how big of a hammer this statute is. It's way bigger than any of the other states that we're talking about. We're going to tell you a little bit about, New Jersey and New York and West Virginia and Ohio. Pennsylvania has a massive potential hammer and penalty associated with not paying your contractors or subcontractors the amount that they're owed. 24% per year with interest and penalties. It really adds up, plus the attorney's fees on top of that. So if we can go to the next slide. So now we're moving on to the new amendments portion of CASPA. Everything we
Matt,
talked
before we
about.
go on, I wanted to interrupt real quick because it does have to do with the recovery. Someone asked on the line whether or not they actually were able to recover all of the amounts of the judgment.
For the first two, the ones that I was involved with, the answer, yes, they were able to recover. I think that there was a settlement of one of them, so the amount awarded by the court ended up, getting settled and paid over time. The final one is not something that I was personally involved with in terms of recovering the money on behalf of that contractor. So, and I know that they were still fighting it as of a few years ago and tried to bring it to the Supreme Court of Pennsylvania, which is why those fees and those costs continued to accrue. So I'm not sure if they got that $1 million out of that developer, but the other two, yes, they were able to recover far, far more than the contract balance.
Good question.
So moving on, now here's the meat of this presentation. Everything we talked about so far is kind of the CASPA basics. It's in a very important statute. Everybody should know how it works and operates. But now there's new components to the statute that were just become effective October 10th, 2018, so just over 2 years ago. And the effective date of the statute as it relates to these particular amendments, it means that contracts that were entered into after that date, these amendments will apply to. So if you have old contracts sitting around or old projects that are more than a few years old, some of these new provisions might not apply in that situation. But going forward, obviously, or more recent contracts that you have, you do have these rights. And these are rights that you have regardless of what the terms of your contract said. Dan alluded to it before about leveling the playing field. The reason why CASPA was initially enacted was because owners are exerting their bargaining power or heightened bargaining power to the detriment of contractors and subcontractors, and putting on some onerous terms that they have to agree to if they want to take on the projects. This tries to level the playing field in terms of bargaining power and give some rights to contractors that they wouldn't ordinarily have in their contracts or subcontracts. So, these rights include the right to suspend work on the project if you're not getting paid. They made it clear that you cannot waive the provisions of CASPA. So if you can't contract around it, and we'll get into that a little bit more detail later, because there are some things that you can contract around explicitly stated within the statute, and we'll talk about those issues. It also provides a new framework for early release of retainage potentially, which could be very advantageous rather than having your retainage sit out there for an extended period of time. And importantly, and Dan will talk about this in a minute, it has very strict and important specific requirements for the notice of withholding. So if you're an owner to a contractor or a contractor to a subcontractor, you need to provide specific written timely notice of the reason for any withholdings, or else you're going to be in violation of the statute. So the first thing I'm going to talk about is the right to suspend work. And this is something that, there are contracts that have this, the ability to do this written in there already, but oftentimes owners, for example, will strike those provisions out of the contract forms and say, there is no right to suspend work. Regardless of whether they do that or not, you have the right to suspend work on a project in the event of non-payment, provided that you follow the terms of CASPA and what it says. So now you cannot waive this right. This is something that every contractor and subcontractor has on a project to suspend work in the event of non-payment. So why would you want to suspend work? It's obviously an extreme remedy, and it's not right for every project. But if it's a problem project, if you see that the writing's on the wall that there's an issue with funding, or there's an issue securing payments, and you have a lot of concerns about it moving forward, you have the ability as a contractor or subcontractor to essentially cut your losses, put the project on hold and say, we're not going to expend any other, costs for labor and materials. We're not going to take on any more risk, putting money out there that we may never get back. It also provides, a big hammer. It's something that you can point to and say, I have the right to do this. I can effectively shut your project down unless you come to the table, deal with me fairly, and resolve some of these payment issues. So, and that's the way I think that the legislature has viewed this as more of a threat, as an option, so that the contractors have some power in that relationship, and will get the owners or general contractors to deal fairly with them and address payment issues. And the reason why I say that's the way I think that the legislature intended it is because of the mechanism that you have to go through as a contractor in order to take advantage of this right. And that's spelled out on this slide that's before you. There's a specific mechanism that a contractor or subcontractor needs to go through before it can finally pull all of its resources off of a project and shut the project down. So the mechanism is, if you add it all up, it's a 70-day period of time from the end of the billing period until the final day that you can walk off the project. So CASPA, as Dan told you before, it contemplates a 20-day period of payment period, and that might be different based on the contract, and the contract will govern. But after the end of a billing period, it contemplates that a contractor, a general contractor, will be paid by an owner within 20 days. So this provision says, all right, well, if you haven't been paid 30 days after that billing period, and right now we're looking at specifically at a subcontractor with subcontractors' obligations. I will get to the contractor in the next slide. But if a subcontractor has not been paid by the contractor within 30 days after the end of the billing cycle, then it can put the contractor on notice that it will intend to suspend work if it's not paid, and that it expects payment to be made. And that written notice can be made via email. It can be made via regular mail. It doesn't have to be anything special. It just needs to be in writing and sent to the contractor. If 30 additional days go by as the subcontractor and you still have not received payment from the contractor, then you can take it up to the next level. And at this point, you can contact, or you need to contact, the owner per the statute. So you provide written notice to the owner, and that written notice needs to be via certified mail. Email's not good enough. Mail's not good enough. It needs to be certified mail so that you know that the owner has, signed off as receiving this written notice that you as a subcontractor have not been paid. It's been 60 days now, and that you intend to pull off the project and suspend work on the project. Then you have another 10-day period of time you need to wait after giving that notice to the owner. After that 10-day period of time, if you still have not been paid, at that point you can pull off the project, stop working without penalty. And that's the key, provision here. You can always pull off a project, but the key is you can pull it off without penalty, meaning that you're not going to be responsible for delay damages. You're not going to be on the hook for them hiring somebody else to perform the job that you're not doing. You're not going to be held responsible for breach of your contract. You have the absolute right per statute to pull off the project, shut the project down, be the squeaky wheel that makes them address your payment issues and get you paid before you can go back and the project can move forward again. And I'll take a look at the next slide. Here's what the procedure for contractors. It's very similar. The only difference really is that obviously both of the written notices need to go to the owner of the project, not to any contractor or anything. So the first notice is 30 days after the billing period. If you haven't been paid, written notice via email or regular mail that you're missing payment and that needs to be addressed. 30 days pass and you still have not received payment. That's when the second notice comes in. That also needs to be done via certified mail to the owner. and then saying 10 more days, and then you can withdraw from the project and suspend work. Obviously, the suspension will end at the time that you're paid in full. Then you can go back to the project and complete. But this is just a remedy, obviously, for and it's important. It's an important way for a contractor to have bargaining power, level the playing field, and it's a good threat that makes the owner deal with you, or makes the general contractor deal with you and resolve these payment issues, because nobody wants the project to be shut down. And this is a way to make sure that doesn't happen by giving you that 70-day period of time to have that negotiation with the owner, with the general contractor, before the project gets shut down.
Okay, so let's move on to the new the amendments on withholding. So the prior version of CASPA always had provisions for withholding for deficient work. That was always there. There was a requirement to provide written notice of the withholding of the deficiency item within a certain period of time. That was always there, but it didn't have a lot of teeth to it. Now it's really stepped up. So when we're talking about withholding money from a contractor to a subcontractor, the contractor has to notify the sub and the owner, both parties, in writing within the time specified in the contract, or 14 days after becoming aware of a deficiency item. This is one area of the statute that, because it was kind of drafted after the fact, it's not entirely clear. It reads as if the contractor, the general contractor, is getting some kind of a notice from the owner about a deficiency item. That's one way to catch wind of it. But, you know, without the owner, if you, the general contractor, become aware of some deficiency item, you're going to want to alert the subcontractor in writing, either in accordance with the time period in your contract or these 14 days. Because if you don't do that, look at the bold and the asterisk in the middle there, failure to do so means you are giving up your right to withhold payment of that particular invoice because you failed to notify in writing that there was a deficiency. We haven't seen that come into play yet in court because the statute and the changes are still pretty new, but that's a very powerful tool. And, you know, the lawyer in me thinks to myself, if this comes up in court and there's no written deficiency item, I'm probably going to file a motion for summary judgment and try to get that particular payment as a matter of law awarded to my client before there's ever even a trial. So that's how I view that. What the contractor needs to look at is 14 days isn't a very long time in construction, certainly not when you're talking about billing cycles and pay periods. So this statute, this is one of the rare instances. Now, you heard Matt say that you can't really waive or contract around the CASPA provisions. That's new to the statute. But this is one place where it specifically gives you permission. It says, if specified in the contract. So this is an opportunity to grow that period of time. Otherwise, you're stuck with the default notice period. Just looking here, it looks like we have a couple of questions here. One is this writing acceptable via email? I assume that's in reference to the deficiency item since the question just came in. And my feedback is yes. I don't believe that there is, you know, Matt talked about a certified mailing requirement when you're notifying the owner of potential suspension issue. This doesn't really say that. So for me, for my money, email is good enough. Getting it out there and having a record of it is good. Another question, is there a difference between a deficiency item and a punch list item? I would say in its purest form, the way I understand the terms to mean, yes, there is a difference. Your contract might have their own special definitions for what a punch list item, repair, warranty item, but just thinking about general practice, a deficiency item ties to something that you screwed up, that you have to go back and fix or repair, and a punch list item is something that I consider you get after achieving substantial completion or getting very close to it and having a few scope items left to perform in order to achieve final completion and get your retainage. So I distinguished between those two terms, and I believe that the statute does it well as well. Again, you have freedom of contract. You can make any definitions that you want in your contract, but traditionally, that's how I would see that. Another question, does this apply to Maryland and DC? The answer is no. In CASPA, we're just talking about projects that take place in the Commonwealth of Pennsylvania. The real estate is in Pennsylvania. Maryland and DC have their own prompt pay statutes. Our contact information will be included at the end. If any of you want to send an email, we've definitely done webinars as a firm on the DC, Virginia, and Maryland area. So I probably have some slides stock ready that I could turn over to you. So don't hesitate to email about that. I think that gets to the questions for right now. So coming back to withholding, again, you've got to put it in writing and you've got to do it on time, or you've waived the defense. You always have to give payment, make payment for work completed that's satisfactory. And again, the point here is if you don't notify the contractor in writing about the deficiency item, it is presumed that all of the work in that invoice is satisfactory and needs to be paid. Now let's talk about the owner withholding payment to the contractor. There's important differences here. And, you know, maybe this is a feather in the cap for your lobbyist, Mike Oscar, because I don't think the owners and the developers got the same quality lobbying as the contractors did. Because you'll see here, same provision, sort of. Written notice needs to go from the owner to the contractor within 14 days of getting an invoice that has a deficiency item. But here's the difference. There's nothing in this section there was in the prior section that suggests you can enlarge in that time period. So basically, the owner has 14 days to issue that deficiency notice, and there are no exceptions. Again, that is nothing. That's no time. That's 2 weeks. And any owner that's either doesn't have their head in the game or kind of relaxes their vigilance is opening themselves up to a more vigilant contractor who's keeping an eye on this and knows that 14 days, no deficiency notice, the payment has to be made as a matter of law. So old CASPA discusses invoicing error as well. It refers to, but here the new part of the statute says that if you get an incorrect invoice, there's still the obligation to pay the correct amount when it's due. So in some ways, the burden of identifying these errors in part is on the payer party, and that's new to the statute. This may not come up if you have a pretty standard pencil copy process where the contractor and the sub are going back and forth saying, no, you're not 75% complete. That doesn't look right to me. And it's more of a negotiated process. But just know that errors do not excuse you from making payment downstream. Let's move on to the release of retainage. This is another new item, and it provides an opportunity for contractors and subcontractors to get their retainage upon achieving substantial completion, not just of the contractor's work, but of the subcontractor's own scope. This is a place where you'll want to check your contract because substantial completion tends to be a defined term. We all have a sense of what we think it means. Typically means beneficial use of your work, but you never know what the contract's going to say about it. But when you achieve substantial completion, if you post a maintenance bond with an approved surety at 120% of the value of your retainage, that obligates the owner or the contractor to release your retainage, provided there's not a notice of deficiency in the project record. So if this is one of your biggest projects, and 5-10% of your contract is a huge amount of money, you've got cash flow issues and you need that money in the door, you can procure a maintenance bond and get that retainage early before you achieve final completion. There's also limits on how long retainage can be withheld, even if you don't procure the bond. Regardless of the bond, retainage cannot be withheld for more than 30 days after final acceptance of the work. So if you don't get a maintenance bond to take you to final completion, still within 30 days of final acceptance of the work, that retainage needs to be released. And if it isn't, now your interest, your penalties, those are starting to kick in because that's a violation of the statute. Matt, I think you're going to talk about non-waiver.
I am, yeah, thanks, Dan. So there's new language in this statute now that essentially says parties, you can't contract around the provisions of this this statute. So previously, that was dealt with more on the basis as it came up to the courts. So people were confronted with this statute. They modified their contracts to address it. I mean, I know that we represent general contractors and have standard contract forms to their subcontractors that say, yeah, these provisions they don't apply. CASPA provisions don't apply to this particular project, and because they have bargaining power to do so, and subcontractors might want the work. A lot of subcontractors would agree to that. Same thing with a GC and an owner relationship. And courts kind of responded to that over the years and said, well, you can waive this, you can't waive that. You can't waive the penalty for non-payment, but you can modify the interest, that sort of thing. But now the statute has taken that power away from the courts and put it back in the legislature and said, here's the situation. You can't waive any of the provisions of this statute within a contract, except as provided for within the statute itself. So all the new stuff we talked about with the maintenance bond in lieu or to support release of early retainage, the suspension of work for non-payment, all of that stuff cannot be waived by the contract, either by a contract with an owner or the contract to the subcontractor. Those provisions will stay regardless. Any waivers of those provisions of CASPA will just not be enforceable by the courts. So there are some things that can be waived or modified by contract, and these are important things to consider when you're negotiating a contract and preparing a form agreement if you're a GC that uses form agreements for your subcontractors. And we talked about these issues already today, but just to repeat them here, the interest amount, the amount of interest owed for late payments, it's 1% per month per the contract, but per the statute, but the statute provides for agreements of a different number. So if you got to pay attention to that interest payment obligation for late payments in your contract. If you're a GC and you're negotiating with the owner, it's better not to have any provisions at all about, hey, I'm entitled to interest for late payments, rather than agree to 6% a year or 3% a year for late payments, because there's no way anybody's going to agree to 12% a year for late payments for interest. So it's better for that contract to be silent between the GC and the owner. It's better for it to be silent than to include an amount of interest that's owed for late payment. So that's something to focus in on as you are negotiating your agreement. Also,
Matt, good. I didn't mean to step over you there. I've got a few questions at a good point. When you're ready to go on to the next slide, I'll just interject them.
Okay, I'll just, my last point that I wanted to make on this slide is that you just mentioned, Dan, the fact that a contractor to a subcontractor can change the time frame in which that he or she provides written notice of deficiencies, and that's key because 14 days is a short period of time, and if you want to elongate that time, it needs to be clearly spelled out within the contractor-subcontractor relationship in the contract itself. What are the questions? Okay,
so we've got a nice collection of questions in the queue here, so let's tick through them. This first one goes back to the retainage questions. and it's a good one. Since there is rarely a final completion document, what constitutes final acceptance, which is usually based on final payment? The short answer is, and this is a good point, the statute does not define the term final acceptance. So that's kind of an open question. And my advice to you is where you're already heading, which is going to the contract and seeing what it has to say about final payment. Sometimes you'll see a definition or enough context clues about what's considered final acceptance, regardless of whether that requires an actual document. So my advice to you would be to look at your contract on what it says about final completion, final payment, and probably use that as the guidepost, because there's no case law yet on this stuff. It hasn't gotten up through the courts yet because it's so new, and they did not define the term final acceptance. So that's a little bit of an open question that you can contract around. The next question, if our invoice is due on the 25th of the month, and we haven't been informed that the owner will pay the GC on the 30th of the following month, are we to assume that the GC must pay us as a sub on the 14th or 15th day of the month because of the 20-day requirement after submission of our invoice? Matt, did you follow that one?
Yeah, I think that this goes back to, and my interpretation of it is this goes back to the provision about the timing of payment. We talked about it a little bit earlier, that there's a pay if paid, not pay if paid, a pay when paid provisions that are kind of built into this statute. And it says that, the GC only is required to make payment within 14 days after they receive payment from the owner. So there's that. In order to comply with the terms of CASPA, their obligation only arises when they've received payment. But that only comes up when the GC has provided notice to the subcontractor of what the billing period is, what the payment period is in the prime contract. So in situations, I think this is the basis of this question, where there isn't that, where that's not provided, is that right? They have not been informed that the owner will pay the GC on the 30th day of the month. So the GC has not taken advantage of the pay when paid provisions that are built into this statute and has not provided the billing dates. Then the obligation is to pay within the time frame that the statute breaks down, which is essentially you submit the bill, they assume that payment is going to be made 20 days after that billing period is over, and then 14 days after that, they assume that the general contractor has received payment. So it would be, I think, 34 days from the time that you submitted your invoice, add in the 20 days and the 14 days. Does that make sense, Dan? Is that how you read it as well?
It does, and in general, it's a helpful reminder to everyone, and that this statute is very mechanical. There are a lot of time frames, notice within this time frame and followed by notice within that time frame. It is very mechanical and technical. There's a lot of opportunity to slip up and miss. Having the statute at the ready, or even just these slides, is always useful to throw into your project notebooks, into your project manager's notebooks, because it is a lot to think about, to the point where even we have to go back and look it up, before we, might put something in a letter. We know where the law is, but there's a lot to remember here. So I would keep that stuff at the ready. Another question here is the retainage provision applicable to engineering services contracts. Engineering firms typically do not have a bond. Very good question, very good point. What I'll say is, engineers fall under the bucket of the contractor definition in this statute, typically, because they'll usually have a direct contract with the owner, making them a contractor. The short answer for me is yes, it does apply to you. You're right that engineering firms don't typically have to have bonding capacity, but remember that this is a maintenance bond. And so what we're talking about here is not a traditional performance or payment bond, but something that obligates you procuring the bond to basically step in the event of a deficiency during this punch list period to cure and correct whatever may have happened. That's a different product than a performance and a payment bond. And I would imagine it's something that you can procure on a one-off basis, even if you don't have a traditional long-standing relationship with a bonding company.
And just to step in here, this specifically refers to retainage, which would be typically held from a contractor until a punch list is completed, between the period of substantial completion and final completion. So it's in that context that instead we're going to substitute this maintenance bond that guarantees the completion of this punch list work and final completion of the project, in lieu of you holding that retainage. So I'm not sure how applicable that would be, or to an engineering contract, or it depends on how your contract is written, but it might just not apply at all depending on how your contract is structured and how the payment is structured. It is definitely intended to help contractors with the release of retainage. So that's the focus of this provision.
Guys, I'd like to take a question.
Sure.
The next question is whether or not that includes the venue provision. I think we're discussing perhaps waiver of rights under CASPA. An example suggested that if an out-of-town CM wants its disputes resolved in their home state, whether CASPA trumps that venue provision. And the reason why I wanted to take this one is because I'm actually embroiled in a piece of litigation over that right now. Actually, CASPA, as well as the public prompt pay statute in Pennsylvania, both have provisions that indicate that any provision in a contract that requires a lawsuit to be filed in a state other than Pennsylvania, where the project is located, is void as against public policy. So the simple answer to that is yes, CASPA would require that if the project is in Pennsylvania, but the contract says that venue lies in another state, that would be void against public policy. The dispute I'm having right now is that the case originally was filed in state court, and state courts follow state laws. But then the case was removed to federal court because of diversity. And federal courts follow federal procedures with respect to venue. So right now we're fighting that in court. So I can keep you updated to see how that goes. But it's our position that, again, the legislature was very clear and with respect to the public policy argument for keeping disputes in Pennsylvania for projects that arise in this state. And then with respect, oh, sorry, go ahead.
Yeah, finish up. I just wanted to talk about arbitration because that's, it's a little bit different ballgame. So I just want to add on to what you're saying. Yeah, so what Lisa said is absolutely 100% correct. And I'm very interested in that federal case to see what happens, with that. But and what Lisa's talking about relates to litigation. A lot of times, there's provisions that say we have to go to court in Utah if you want to, get paid on this project or bring a claim. The one thing you have to be aware of as a contractor is that, and Lisa brought it up with regard to the interplay between federal law and state law, that there are court decisions out there that say that this particular provision of CASPA that talks about you have to bring a case in Pennsylvania does not apply to arbitration agreements within your contract. So if your dispute is not, we're going to go to court, the provision in your contract about dispute says, not that we're going to go to court wherever, it's that we're going to arbitrate this dispute with the AAA, with the private arbitrator, and that arbitration is going to take place in Alaska. That is enforceable per these court decisions because federal law governing arbitrations and the right to agree to an arbitration trumps state law like CASPA that says that disputes have to take place in Pennsylvania. So it gets a little bit hairy there when you're talking about arbitration, and that's why it's important as a contractor to focus on, not as much as Lisa said, the litigation provision in the courts of another state, because that might not be enforceable, but with regard to arbitration, that is enforceable, and it's something that you need to change because you don't want to go to Alaska to resolve your dispute. You want to do it here in Pennsylvania if that's where the project is.
So the most recent two questions are direct follows to this topic, so I want to stay with them. And that's some clarification. The question is whether the current topic has to do with choice of law in a contract. And we're talking about venue right now in terms of where the dispute is actually going to take place. But I do believe that the same provision also requires the litigation has to take place in the Commonwealth of Pennsylvania. But what about the law that applies to the dispute? Can you also contract around, say, you know what, fine, we'll do the litigation in Pennsylvania, but New York law is going to apply?
Yeah, I can address that as well, because under the exact same provision that says you can't be forced to litigate a dispute in a state other than PA, that same statute also says that you can't be forced to apply another state's law with respect to a project that's in Pennsylvania. So to answer that question, yes, it's the same thing. So PA law has to apply for private projects in Pennsylvania as well as public, and you need to litigate disputes in PA if the project is in PA. So any provisions in your contracts that say otherwise would be deemed null and void under these statutes that we're talking about today.
Now I'm going to tie that question back, thank you, Lisa, to another question in the queue, and that is, can you review a subcontract? Oh, I just lost it. Can you review a subcontract before signing it to point out the loopholes the GC has in place in the subcontract? I assume that means some of the missing pieces or the things that are inconsistent with the CASPA statute. And absolutely, I mean, we as a firm do contract reviews for our clients before they ever sign up all the time, because you're trying to, even if it's to point something out that your customer will never negotiate around, at least you now have the prior knowledge before you jump into the project to know where the landmines are. And also, as a good negotiating tactic, if you find a provision that you know is unenforceable in that subcontract, while it may be good practice to say, look, this isn't enforceable to begin with under CASPA, I want it out. You can also say, you know what, this provision isn't even that important to me. I'm going to say I'm letting that one go, and I'm going to go try to negotiate around the pay if paid clause. So there's all kinds of ways to use this statute and your knowledge of it to your advantage. And the last question, and then I promise, Matt, you can finish non-waiver.
Oh, that's all right. It looks like there's two more questions.
Two more. All right. Well, I'll take this one, and then you guys can read and respond to the rest of them. Is incorporation of the prime contract by reference into the subcontract sufficient to provide notice of the payment terms to the subcontractor? This is a reference to the obligation to share with the downstream parties when the owner is going to pay the contractor. Matt and I fielded this question in a prior webinar, and our advice is no, that's not enough. You really want to give actual notice. It's not going to be enough to say this is incorporated by reference. Even if it's just a copy and paste in an email, the provision that says the owner is going to pay the GC within 45 days of an acceptable invoice, do yourselves a favor, provide that in an email, provide it in the redacted subcontract or contract, whatever you need to do, but don't rely on the incorporation by reference clause, because a court may not find that sufficient, and you really probably should give actual notice.
All right, and the last question that I see is, what if the GC withholds their billing to the owners to break the back of a small minority subcontractor? Essentially, if in the situation you just described, Dan, they've provided that notice of the billing timeframes so that it turns this statute into more of a pay when paid situation, where the rights of the subcontractor don't come about until they are the GC is actually paid. So there's a thing in Pennsylvania law called the prevention doctrine, And when a party to a contract purposely does something, withholds, some sort of act, including failing to provide this application for payment to the owner, that prevents a condition from coming into play, then they will not be able to rely on that situation to their advantage. So to put a finer point on it, a GC who prevents, through their own actions, prevents the payment from being recovered from the owner by, for example, not submitting the application for payment, cannot turn around and take advantage of pay when paid provisions. That their obligation will come up regardless of that pay when paid. So it's a good question, and it's not a good practice for a GC to do that, obviously, because Pennsylvania law recognizes you can't have it both ways. You can't prevent something from occurring and then rely on the non-occurrence of that event to not, undertake your obligations under the contract.
Okay. So why don't you reorient yourself to where we were, and we can come back to the slides.
We're wrapping up here. So, just the end of our, we welcome, obviously, a whole bunch of other questions, but we're wrapping up the new CASPA changes, and we're going to move on to a couple of other states, surrounding states, that have similar laws or a little different. We're going to explain some of the how they're similar, how they're different. But before we get to that, we just want to, kind of hammer in some of the key points that we talked about. So this is be on the lookout for. So, go back to that last.
Excuse me.
Yeah. So we talked about this a number of times. The important provision, this 14-day time frame to provide written notice of deficiency items, or else you waive your right to use those deficiency items as a basis to withhold payment. That is key. It's very, very important, and it's something that you need to, always be thinking about as a contractor. Once you submit that application for payment, if the owner doesn't come back within 14 days, then they can't withhold payment from you for that particular that particular application for payment, or else they're violating CASPA, and that opens them up to interest and penalties. So, that's a very key provision. So you get to, start the clock running on that 14 days. Also, as a general contractor and as a subcontractor, that relationship, you need to take advantage of that, be really cognizant of, that period of time. If there are deficiencies in the work that are going to result in payment being withheld, you need to jump on that and provide written notice of that. You can't just talk about it in a meeting. You need to write an email or write a letter and identify the amount that you're withholding, the reason for the withholding, and do all that quickly within 14 days. And that's a strict requirement of the statute, that notice requirement, and it is likely to be interpreted strictly by the court. And if we go down to the next slide, it's kind of the summary of all of the amendments we talked about today. These are all the new provisions of CASPA that are designed to help you, that's designed by the legislature to help you as a contractor or subcontractor gain some bargaining power and assert your rights to payment. So you got the right to suspend work without a penalty. That's important. Be the squeaky wheel. Make sure that you are getting paid and these issues are addressed. Remember, it's a 70-day time period before payment would be, from the end of the billing period to when you can walk off the job and suspend work. And in that 70 days, there's a couple of notices required in order to, stimulate some sort of dialogue between, the owner and the GC, or the GC and the sub, about payment. There are, we just talked about this, obviously, the withholding payment for defective work. Important to identify the amounts you're withholding, the reasons for the withholding, and do that quickly. Also, you need to pay just because there's a deficiency item. Say there's an application for payment for $100,000 and there's a deficiency item that's valued at $10,000 that needs to be addressed. CASPA requires you to pay the $90,000 delta between them. You can't withhold the whole application for payment based on one deficiency item. You need to pay everything that's not deficient. So that's key. Also, you can get early release of retainage by posting a maintenance bond, which could be potentially very valuable on a project. Sometimes, issues, that it's not anybody's fault, but there's the project, even though it's substantially complete, just kind of drags on and does not get final completion. It could be weather, it could be, it's always the retention basin we've seen a lot where that, it's not working and needs to be worked out. You can have a bond written that gets all the retainage released, so you have access to that money while you're working through all these issues. That could take months or years in some situations. As Dan mentioned, the mistakes on the invoices themselves are not an excuse for non-payment. That needs to be worked out, and payment needs to be made regardless of those errors. And as I just talked about, these CASPA protections, other than the couple that we mentioned, cannot be waived or modified by contract. So that's something that you have the right to, despite the bargaining power issue. You have these provisions of CASPA allow you to level the playing field, and they cannot be waived by those upstream. So,
all right. So at this point, we're going to move to other states. We will not get into the same level of detail, but being that we're talking here to the Western chapter of PA, we also want to include some helpful jurisdictions. So Lisa, why don't you start to walk us through some of the other states here?
Sure. So yes, Pennsylvania is not the only state that has a prompt pay statute. What is critical, and when you go from jurisdiction to jurisdiction, is to really find out whether or not the state that you are performing work in does have a prompt pay act, because they all are going to have their own individual rights and remedies. So let's talk about Ohio. Ohio has what's called the Ohio Prompt Payment Act, and that actually is going to lump in rights and remedies for both private and public construction projects, with a similar exception like the PA statutes, where it doesn't apply to certain residential projects. With respect to Ohio statute, the payment terms that are required from a GC to a sub is 10 days from receipt of payment from the owner, and the subcontractor also has to pay its lower tier subs and suppliers within 10 calendar days of receipt of its payment from the GC. The Prompt Pay Act in Ohio also has some release of retainage requirements like CASPA does. Retainage can be withheld on a project in Ohio, but it must be paid within 10 calendar days of receipt, as long as the work has been completed in a satisfactory manner and approved by the owner. They can shorten that time frame in the contract, but they can't enlarge the period of time for retainage to be released. Like the Pennsylvania statutes that we talked about today, there are penalties associated with not complying with the prompt pay requirements of the statute. Failure to make payment within the required time period will result in an automatic 18% per year penalty that starts to accrue beginning on the 11th day of non-payment. You do have to wait 30 days to file a lawsuit from when payment was due to collect the amount due plus the interest. And under Ohio's Prompt Pay Act, the prevailing party in any litigation will be entitled to reasonable attorney's fees and court costs unless it would be deemed to be inequitable. And lastly, again, like the Pennsylvania statutes we discussed today, any provision in your contract that waives your right to interest, attorney's fees, or court costs on an Ohio project is void against public policy. You can't give up those rights in a contract if you're working in Ohio. The next state we wanted to cover was West Virginia. West Virginia does not have a statute that addresses prompt payment for private projects, but there is a prompt pay statute that's going to apply to public projects. Notably, however, the rules under this Prompt Pay Act and the remedies available only apply to payments from owner to prime. So if you're a subcontractor, you can't take advantage of this public Prompt Pay Act either. So I would say as a subcontractor in West Virginia, there's really no statute that's going to give you rights and remedies like the other prompt pay statutes we're talking about today. If you're on a public project and you are a prime contractor, any property that's registered, any properly registered and qualified vendor who supplies services or commodities to a state agency, they're entitled to prompt payment as long as you present to the state agency a legitimate, uncontested invoice. A state agency is going to include any agency, department, board, office, bureau, commission, or authority, or any other entity of a state government. Under this Prompt Pay Act, with respect to public projects, payment is due within 60 days of the invoice. Entitlement to interest is going to be based on legitimate and uncontested invoices that are not paid starting from the 61st day after the invoice was received until the date when the check is mailed to the vendor. So, you know, when we were looking at, Matt went through his calculations, again, it's not until the check is actually in hand that the interest calculation stops accruing. The Prompt Pay Act in West Virginia does provide a definition for what makes an invoice uncontested, and that really is just as long as it accurately covers the goods and services received. There's one caveat in order to get your interest. If you have a late payment from a government agency, you have to make sure that you request in writing to the state auditor that payment for interest be made, and you have to provide proof that the vendor received a check for payment of the invoice after the 60-day time limit. So again, the interest is going to come after you've made a request for the interest and after you've received the payment. And unfortunately, there is no attorney's fees provision in the Public Prompt Pay Act in West Virginia.
So this is, of course, a really good example of just how, you know, Pennsylvania compares with other states. There's not a lot here in West Virginia, particularly for the subcontractors. Before I dive into the next state, which is going to be New York, we have a PA specific question. Does it violate CASPA if a general contractor fails to pay a sub because partial third-party waivers were not submitted for that period? With a 14-day notice period still apply on the part of the GC? So this is a good question, and it's a reminder that while we've been really focusing on deficient work because the statute refers to deficiency items, the other traditional ways in your subcontract that justify you withholding payment, whether it's for failure to provide a subcontractor partial release because that's a precondition to payment. My take is that that's not intended to be at play here. As opposed, it is a deficiency. It's a contractual deficiency, but it's not a deficiency in the workmanship that would otherwise justify withholding the amount of money tied to that poor workmanship. Lisa, Matt, do you guys have a different or similar spin on that?
The thing about CASPA is, and the reason why, you know, I'm sorry to tie this back in, the reason why I said that, you know, the effective date of the statute only applies to contracts, and the new terms only applies to contracts that were entered into after the date, is because there's such an interplay between the terms of the contract and the CASPA requirement. So in this situation, payment needs to be made in accordance with the terms of the contract. That's what the requirement is for CASPA. So it reads into the fact that there are payment requirements within your contract that need to be complied with. The contract and CASPA need to be kind of read together hand in hand. So those things, for example, hey, you didn't provide an insurance certificate, so I don't have to pay you. That's no problem with your work, but it needs to be done in order to, as a condition for payment, and something you see typically in a contract, and that's something that you need to provide. So the answer is it does not violate CASPA by withholding payment for the reasons that are identified in your contract, including, insurance issues, those waivers that need to be signed on a monthly basis, that sort of thing. So if you want, from a tip from an attorney's point of view, if you want to address those issues about what it takes to receive payment, or I don't want to sign this partial waiver, or I don't like the language of the partial waiver, those are issues that you should address at the time that you're entering into the contract. Take a look at the, because usually they're attached as exhibits or they're available. Take a look and see what those waivers actually say, and see if there's a way to negotiate some of the language of that, so that there's something that you're comfortable signing in support of those payments. So short answer, wordy response, but the short answer is no, that's not a violation of CASPA. You can withhold payment if they don't, comply with the requirements of the contract.
Thank you. Let's talk about New York. New York also has a prompt pay statute. It doesn't have a very interesting name. It's just called General Business Law Section 756. Very exciting. This applies to private construction projects. Some residential exceptions, like 3 units or less, or 4,500 square feet or less, and things of that nature. And like Pennsylvania and other states, the stated purpose in the statute is to expedite payment of all monies owed to those who performed contracting services under construction contracts. Again, it's not that interesting to say the statute requires you to pay in accordance with the terms of your contract. Well, of course, you signed a contract. That's what you should do. But as we all know in the industry, things don't always flow down the way they're supposed to. And this is supposed to add some bells and whistles to level the playing field. So there's a 30-day billing cycle, but it can be modified in the contract. Owners, contractors, and subs alike, they all have 12 business days to either approve or disapprove of an invoice, all or part. And disapproval, again, very similar to Pennsylvania, requires the paying party to issue a written statement describing the items withheld. That means, you can't, to use Matt's example, you can't withhold all $100,000 when you know that there's $10,000 worth of poor work behind the wall that needs to get corrected. You got to pay the $90,000, hold on to the $10,000, and tell them in writing within 12 business days why you're doing what you're doing. Retainage, this is identical to Pennsylvania, 30 days of final approval of the work. I don't believe that term is defined. So again, to come back to one of our prior questions, you're really going to want to study the contract and try to resolve those issues at the time of contract. And again, the pay terms can be modified by contract, as they often are. More parallels to Pennsylvania. Contractors and subs have to disclose their upstream payment terms. Otherwise, you're going to have this presumption that the owner has paid the contractor. It doesn't necessarily say you have to provide the owner's pay terms, but you definitely need to disclose the upstream pay terms. So if you're a sub and you're dealing with one of your subs, you got to tell them when the GC is going to pay you. Subcontractors can actually reach out directly to the owner to figure out if an interim payment has been made from the owner to the contractor. We have that sort of in the suspension provision in Pennsylvania, because if you're not being paid within 30 days, then you're going to write to the owner and say, I haven't been paid by your GC, what's going on? So there's a permission to go around the contractor to do that. Interest is 1% per month, which is that 12% annual that we saw in Pennsylvania. And there are suspension rights, very mechanical. There's a lot of notice requirements to comply with, so be wary of that. Contractors have the statutory right to submit these disputes to arbitration, and that can't be waived. It doesn't require the disputes to be handled at arbitration, but they have the option. So waivers of arbitration rights are not enforceable. Lastly, I'm not going to talk about public jobs because New York has 4 different statutes, depending on whether you're performing work for a state, for a municipality that is not New York City, or New York City has its own statute, and then a public authority. The windup is pretty much the same across the board. The interest rate, as it is in Pennsylvania for these public prompt pay statutes, significantly less than the private prompt pay statutes. I believe what I read in New York was right now the rate is 2% annual, because that happens to be the overpayment rate with the New York Treasury Department for overpayment of taxes. 2% is not a lot. And that's what you're getting on the public jobs, because you're dealing with taxpayer money. So we're not going to just give away the farm. Now we're getting just briefly outside of the prompt pay statute in New York, because there's some uniqueness here. In New York's lien law, it actually says that funds on a construction job, whether it's public or private, so this includes private, general contractors and subcontractors who are being paid money for subcontractor work, that's not their money. It's held in trust. So that's a heightened obligation, and it comes with civil and criminal penalties, because you're placing the money in trust. So the subcontractor who actually did the work is a beneficiary of that trust, and they have rights just like any other beneficiary of a trust. They can demand accounting of how the funds are being received and accounted for and handled, and contractors and owners have to comply with that. Otherwise, they're in violation of these trust fund provisions. That's pretty unusual. New Jersey has a public one, not private. Pennsylvania doesn't have any kind of trust fund. That's a big remedy. And lastly, New York has made pay if paid provisions void as a matter of public policy. You won't find that in the prompt pay statute. You won't find it in the statute at all. But the courts in New York have said to uphold the pay if paid provision is to take away subcontractor lien rights. And that can't happen because we don't allow waivers of lien rights. So that's how the courts looked at that one. And it resulted in no pay if paid, pay when paid, which is not quite as risky and harmful. They can still be enforceable, but not pay if paid. So Matt, why don't you bring us home with New Jersey?
All right, this is the last one that we're going to be talking about. State of New Jersey. It has a Prompt Payment Act that applies both to public and private construction projects. It provides for, as it relates to payments from an owner to a prime contractor, a general contractor, it provides for a payment schedule that it can't be changed by contract. It says, here's how payments are going to be paid, and first step is the approval and certification of that. So within 20 days after you have provided an invoice in New Jersey, the application for payment or the invoice will be approved and certified upon the owner's 20 days after the owner's receipt, unless the owner provides a written statement of the reasons for withholding money. So they have that 20-day time frame. In Pennsylvania, it's 14 days. In New Jersey, it's 20 days. They have that 20-day time frame to provide a written statement of the reasons for withholding any amounts of that application for payment. If they don't provide that, then the payment to the prime contractor is due within 30 days after the receipt of the invoice by the owner. So that's a 30-day time frame. Doesn't say or as agreed to in the contract. The prompt payment statute requires that payments from owners to general contractors be 30 days. Subcontractor payments, and here again, there's a concept of pay when paid that's written into the statute. Their payments are due 10 days after receipt of the contractor's payment from the owner, or per the terms of the contract. So here, between a contractor and a subcontractor, you can provide a different period of time to make a payment after receipt of that money by the GC. So it's similar. Sorry, go ahead.
I have a couple of good questions that tie into to the mechanics that you just went through.
Sure.
So let's put you on the spot here.
I'll answer them I can answer them pretty briefly. So the questions are,
go ahead.
First,
yeah.
Are we talking about calendar days here or business days? calendar days. The answer is calendar days. That's what we're talking about. And second, and maybe I misstated it, the 30-day time frame runs from the date of the time that the invoice is submitted to the owner. So it's not not after it's certified. So if it's not a 50-day period of time between when you give them the invoice and when you get payment, it's a 30-day period of time. It is, but the first 20 days of those 30 days is the period that the owner has to provide a written statement of the reasons for the withholding. And then, but 30 days is the time frame for payment in New Jersey. So the penalties, though, in New Jersey for not complying with this are not nearly as severe as some of the other states. And we looked at New York, it's what, 12% per year interest. Ohio is 18%. And in Pennsylvania, if you get interest and penalties, that's 24% per year. So those are severe penalties. In New Jersey, all you get is interest recoverable at the prime rate plus 1%. So 1% over the prime rate, it's not a whole lot these days, a few percentage points of interest. But the good thing is you do get attorney's fees and costs awarded to the prevailing party, which is positive. So you're not going to lose money chasing after a balance by paying attorneys. You'll get your attorney's fees as well as the balance that's owed. A couple other points, if you go to the next slide on the Prompt Payment Act. I talked earlier about the right to suspend work in Pennsylvania. You also have that right in New Jersey, except for in New Jersey, it's a lot easier to get there. Where it was 70 days in Pennsylvania, it's 7 calendar days in New Jersey. So you need to provide written notice as a contractor within of non-payment and then within 7 days of that written notice, you can suspend work on the project without penalty. There's a couple of caveats here. That 20-day period of time where the owner has a right to provide a written statement of the amount withheld and the reasons for withholding, there can't be that. There can't be a reason or a basis for the owner to withhold payment and notice being given by the owner in accordance with that statute. So if that exists, if they provide that written statement, then you obviously cannot suspend work on the project. And they're also, and this is a little bit not as well defined, but there can't be a good faith effort to resolve the reason for withholding that's going on between the owner and the contractor at this period of time. There can't be a dialogue that's, oh, we need to address this invoice issue or that issue or whatever. They can't be acting in good faith here. If they act in good faith, then you can't suspend work on the project. You can only suspend work on the project if they stonewall you and just aren't paying or don't provide a reason or a legitimate reason and are generally not acting in good faith. All right, so with that, I think that we have completed all the other states, or the survey of the other states' prompt payment laws. And we're going to open up. We've taken your questions throughout the presentation. Let's see if there's any others. I don't think there are right now, but if there are any other questions, certainly raise them now. We have a few extra minutes to answer them. I want to thank you all in the meantime. I want to thank you for attending this. It was a pleasure for us that we had to present to you today. It's something that we deal with every day, and we're glad to teach you a little bit of what we know about it. And hope that what we told you makes a difference in how you conduct your business. And also thank you for the questions today. They were fantastic questions, really great, and kind of help move the presentation forward. We always like to interact more, answering questions and going back and forth. It really breaks up the presentation and makes it more of a conversation. So I really appreciate that. And if there's anything specifically that you want to raise, any non-payment issues that you're seeing on your projects, please don't hesitate to reach out to us. There were some questions about contract reviews, subcontracts, GC contracts with the owner, to make sure that those provisions line up with CASPA and benefit you. Certainly, we're all available to take a look at those and comment on it. And please don't hesitate to reach out to us and with any questions you have. And our contact information is up on the screen.
So let's just, before we go, and I echo everything you just said, Matt, we have one question that came through on New Jersey. What about retainage disputes between the owner and the prime affecting payment to the sub? Any way to get the sub paid?
So, unfortunately, for a subcontractor, provided that the GC is trying to get payment and doing what they need to get paid, the payment is only due to a subcontractor under the Prompt Payment Act 10 days after the contractor's actual receipt of that payment. So if the contractor hasn't received payment because of some issues I mentioned before, something that's nobody's fault, but it's dragging on for one reason or another, and no final payment has been made, the Prompt Payment Act does not provide that remedy to say that payment needs to be made. So there's a pay when paid written in. So the ways around that, and there's no provision like in Pennsylvania with the maintenance bond, which is a great provision, that doesn't exist in New Jersey. So the only way to address that would be on the front end. So take a look at your contract and try to maybe negotiate on that point where the release of retainage or portions of the retainage within a certain period of time, regardless of when payment is received by the owner. That's really the only way to address that, is to actually do that within the context of your contract.
Are you seeing the last question there, Matt?
So the answer to that is yes and no. So you can contract around the Prompt Payment Act only as it relates to, in New Jersey, only as it relates to the time frame where a general contractor has to make payment to its subcontractors after receiving payment from the owner. It's 10 days in the statute, but that can be changed. And the Prompt Payment Act addresses that. It does not change, does not address it in the context of the owner to GC payment requirements. That 20 days needs to stay firm, and that 30 days for payment, it needs to stay firm. So you cannot contract around that, or the interest is a minimum interest requirement of prime plus 1%. You can always add interest onto that if there's there's some sort of agreement that there's going to be more interest applied, but you cannot remove the right to attorney's fees or interest or the timing of payments from an owner to a GC.
So thank you, Matt. Let's wrap there, and let's marvel at how 3 lawyers somehow only went over by 2 minutes. I think that's the first time in history. So thank you again, and we will see you at the next one.
Yeah, thanks everyone.
Thank you.